Hey Cyberclass, it's Professor Opterbeck, and this is the video I promised on the Netchoice cases, of which the Supreme Court has just taken cert. And again, I'm sorry this is a little bit late. I had to take over the IP licensing class because of an emergency, and so I'm a little behind this week. But these are really interesting cases, and this going to the Supreme Court is potentially really important. We'll see what the court does with it. All right, so I'm not gonna spend any time really going into much of the background and the facts and so on. You can read that in the cases. And if you poke around a little and look at a little bit of background on these cases, you'll see that they come out of this kind of wave of concern on the right about social media companies' content moderation practices and account practices. And so, as you probably know from seeing this in the news over the past few years, conservatives have claimed that the social media companies are setting up their algorithms, their content feed algorithms, their filters, and so on to keep content from some conservative speakers lower in people's feeds. It was called shadow banning. And most of the companies denied that they were doing this, and so there's kind of factual issues about whether that actually happens or to what extent it happens. And then, of course, there were notable conservative figures, not least, of course, former President Trump on Twitter, who were deplatformed by the companies, as well as others. And the companies, justification for that was, well, some of these figures are, speaking in ways that are contrary to our policies. President Trump, they argue, incited the events of January 6th and other things like that. And some of the other speakers, they argued were perhaps adjacent to hate groups, to neo-Nazi groups or other things like that. And again, there potentially are factual issues with all of those claims. We're just going to set those factual issues aside for the purpose of our discussion, because the factual issues are not really the central question. The central question in these cases is, all right, let's assume that indeed the big social media companies, X, formerly known as Twitter, Facebook, Instagram, YouTube, whatever one of these platforms you want to mention, let's assume that they are indeed engaging in content moderation, which of course they are. But let's assume that content moderation includes filtering out to some degree or another some viewpoints that the company, as a matter of policy, deems undesirable, that might not otherwise be unlawful, right? And or that the companies are barring some users who the company deems undesirable, where those users are not otherwise, kind of criminal actors, right? So let's assume those facts. Assume that the social media companies are doing that, and if they are doing that, are they in fact entitled to do it? And that raises, some specific legal issues, but these legal issues really get to the heart of how the internet has been understood and has been regulated or not regulated in the United States since the early 1990s. So it's not just a kind of interesting, naughty First Amendment case. It is that, but it's actually a bigger case about the internet governance and the nature of the internet. All right, so the first part of this is the First Amendment claim, right? And the social media companies say, to the extent we are engaging in censorship, we're entitled to do that under the First Amendment. Those are editorial decisions. Now, that word censorship obviously is politically loaded, right? Has all this political valence, because we intuitively, many of us as Americans assume censorship bad. And, we might be right to have that reaction when we're talking about the government, right? The government acting. For the government to censor speech is quite an obvious First Amendment issue. And normally we'd say the government should not be engaged in censorship, right? We have free speech rights. And that's generally true, but of course there are categories of speech that even the government does censor. I mean, the government censors child pornography, and I think all of us would agree, rightly so, right? And that is a category. We will get into this in another week or two, but you'll read New York v. Ferber, and you'll see that the Supreme Court said, yep, that's a category of speech that is simply unprotected, right? The government can censor it. And we have a few categories of speech: incitement to violence, and a few limited categories where, yeah, the government can censor. But in general, we say, look, if speech is just offensive or you don't like the political standpoint, no, the government can't do that. But as we saw in the cases on state action that I had you read this week, pretty uniformly, courts have held social media platforms are not state actors. It's not the government. Now, there were some on the right who were trying to really push the argument that the social media companies should be considered state actors, but that failed in the courts, and as far as I can tell, that argument really hasn't picked up any political valence, really. That fight of trying to make them state actors pretty obviously failed, and then it moved to the state legislatures. So you had in some of the red states, Texas, Florida, and some other places, some of this legislation that was trying to put obligations on the social media companies as to what kind of content moderation they could or couldn't do. Of course, nobody suggested that the social media companies should not be able to censor things like child pornography, but it was about political viewpoint. All right, so first question, are they protected by the First Amendment? And the 11th Circuit said, yeah, this is a traditional First Amendment protection that the Supreme Court in the past has extended to traditional news publishers. So think of the newspaper of choice that you might read, the Wall Street Journal, the New York Times, Washington Post, right? Whatever newspaper you might consume. They're making editorial decisions. They're not just publishing everything that comes over the transom, and they have specific editorial viewpoints. Now many of those big papers try to have some degree of balance on publishing people from the right and from the left, but it's no secret that they all have their inclination. I mean, I read both the Wall Street Journal and the New York Times both days, and it's most days, and it's pretty obvious to see the Journal skews right, the Times skews left, right? They'll publish other voices, but they skew, and that's fine. It's a newspaper. It's a privately owned publisher. They can publish what they want and choose not to publish what they want. And the Supreme Court has some case law saying, yep, that's an aspect of their speech right, the decision not to speak. And the 11th Circuit picks up on that. The 5th Circuit says, no, censorship is not speech. And so the decision not to speak, the 5th Circuit says, is not protected speech. Now, how does the 5th Circuit do that in light of the Supreme Court precedent about traditional news publishers and their editorial decisions? And if you kind of read the majority opinion in the 5th Circuit, you'll see it's a little slippery, but effectively the 5th Circuit is calling into question those precedents, right? So, and that's why you have a bit in there about, well, what's the original public meaning of the First Amendment? The Fifth Circuit judges in the majority there are taking a certain kind of originalist view and are really saying those other editorial opinions are in question. Now, of course, the 5th Circuit's bound by those, but in a case like this, you can get around them and say, well, these are not really newspapers, right? These are something different, these social media platforms. But it is calling into question a longer way of interpreting the First Amendment. It's possible that this case could challenge the way newspapers and traditional news outlets operate. And that's sort of one of the possible big implications of the case. Now, the 5th Circuit also says, hey, look, the social media platforms are different than traditional publishers, and Section 230 expressly shows that, right? Section 230 says that we are not, for purposes of defamation or other kinds of third-party liability, we're not going to treat the social media companies, or, it wasn't social media companies when Section 230 was passed, but the interactive service providers who are taking user-generated content, we're not going to treat them like traditional publishers. We're going to give them a statutory immunity from third-party claims, defamation and other such claims. And the Fifth Circuit, kind of cleverly says, hey, look, they're not traditional publishers. So this is an interesting issue. I suspect, I don't know, but I do suspect that it's probably unlikely, in my view, that a majority of the court, even on the current court, which might be more inclined toward the Fifth Circuit's originalist reading, seems unlikely to me that they would kind of do away with the First Amendment protection for editorial decisions, including what not to publish. That would really upset not just kind of the social media world, but the entire world of editorial news. And I doubt that a majority of the court's going to want to do that, but we'll see. But that relates to this second issue, and this is where I think there's really some possibility for the current Supreme Court to muddy the waters. And that is, are the social media platforms common carriers inherently, and or can a state legislatively treat them as common carriers? So you need a little bit of a background about what common carriers are to have a sense of what this means. Kind of in common law and in statutory regulation, both state and federal regulation, it actually relates back to, as the word carrier suggests, it relates back to things like shipping lines, bus lines, railroad lines, that are actually carrying freight or passengers, and obligations to kind of take whatever passenger walks through the door who's willing to pay the fare, and that kind of thing. And then it extends in communications law. As we get into the age of radio in the 1920s, 30s, 40s, then the age of broadcast television, 1950s, 1960s, and then the age of cable television in the 1970s, it starts to extend as a matter of federal law in the Telecommunications Act to those entities, and saying, right, if you are, and the rationale for it, so if you are broadcasting on the public airwaves, radio, or if you're broadcasting television on the public airwaves, you are called a common carrier, and you have an obligation then to accept programming with a degree of neutrality as to the political viewpoint of that programming, and as to other aspects of the content of that programming. So why were traditional broadcast radio, traditional broadcast television, in this legislative regulatory sense, treated as common carriers? Well, the original rationale, so I'm trying to draw a broadcasting dish here, right? Whether it's television or radio, and if it's radio waves, and if it's the electronic signals that carry broadcast television, there is the possibility of interference. If you've driven down the Parkway and you're listening to your favorite radio station from the New York area, and as you get closer to Philadelphia, right, you start to have your station get interference. It's kind of fuzzy, and then it starts to switch. Why? Because the radio waves are literally right going through the sky, and they only have a certain range. And so for radio and broadcast television, the federal government initially auctioned off the rights to use the radio frequencies within a certain geographic area, right? And you got a license to operate your radio station or your broadcast television station, and aspects of that regulatory regime still apply. And so because it was viewed as we're letting these private companies have a quasi-property right, a regulatory property-like right in a piece of the public airwaves, then we're going to impose an obligation on them as common carriers to use those public airwaves in some kind of somewhat neutral way. Now, when we got to cable television, early cable television took it off the airwaves and ran it through cables, but then after a while it involved satellite, and after a while from that it involved other things. So the regulation was actually tweaked the Communications Act was tweaked for cable providers. And cable providers did originally and still do have some common carriage obligations. It's not all exactly the same as broadcast, but there still are some common carriage obligations. Now, when we get to the internet, and now we're getting to the Telecom Act of 1996, right, which is really amendments to the previously existing telecommunications laws. Congress is facing a question at that time. How are we going to treat the internet? Are we going to treat the internet like broadcast radio and television and maybe give licenses, right, government licenses, and impose common carriage obligations? Are we going to treat it like cable television, and it's not, spectrum going over the airwaves, but there still is some aspect of, closer aspect of government involvement, and there still is some closer aspect of common carriage obligations? Or are we going to do something different and have a much lighter regulatory touch? We're not going to have licensing obligations for someone to get into the internet business, and we're not going to have common carriage obligations. And that's the choice Congress made. The Telecommunications Act of 1996 puts broadband internet service into a different category. And this is what the 11th Circuit picks up on. Social media platforms are not the traditional range of common carrier because they're not using public airwaves or the public lands to run railroad tracks. And Congress specifically decided to put them in a different category. The Fifth Circuit, as you see, says nope, the social media companies do meet the definition of a common carrier traditionally, and the question of regulation is a federalism issue. Right? So at the federal level, the Telecom Act of 1996 put them in a different category, but does that mean states can't themselves regulate them as common carriers? And so there's a federalism issue. There's kind of lurking in the case a preemption issue, but I don't think it's really a preemption issue because I don't think there's express preemption in the Telecom Act of 1996, and it isn't really teed up in the cases that way, but it is teed up as a federalism issue. Now, I'll also note, right, there's one other piece of this that makes it really interesting for internet governance. When we think of the kind of structure of the internet, super simplified, right, you have high-speed cable switches and routers, which we call the backbone. And by the way, we didn't talk about net neutrality in this class, but that is coming live again because the Biden administration is looking now again through the FCC to reinvigorate the net neutrality rules that the FCC under the Trump administration had rescinded. Right? The net neutrality is all about what happens at this backbone layer. All right, so backbone wires, and then you have the wires that we call the last mile. So your provider, maybe it's Comcast, maybe it's Verizon, mine is Verizon Fios. That wire to your house is the last mile. A little confusingly, some of the backbone providers like Verizon are also last mile providers, right? So then you have your consumer here, right? You and your house. And then what we have what are called edge providers. So the edge providers are entities that are out there on the internet, right? So it could be, your local mom and pop shop that has a website, or it could be Amazon, and or it could be Facebook, right? It could be all of those. And this is one of the places where the whole common carrier thing gets interesting because, in my view, more traditionally, it would be these entities that control the backbone that are potentially subject to common carriage regulation. You're literally laying cable in the same way that you might lay railroad tracks, right? Whereas the edge providers are just using that infrastructure. And so there's a question about, well, can these edge providers be considered also kind of more traditionally like part of the backbone? It does connect in a way with the net neutrality issue, because you're saying the agreements between the edge providers and the backbone providers can't include terms that allow sort of special treatment or throttling or something like that. And so it's just kind of an interesting thing about how do we treat these big edge providers. So this has got really significant implications. If we designate large edge providers as common carriers, it's got really big implications for how we conceive of internet governance and internet regulation. Effectively, we'd be saying individual states can treat these entities as something different than what federal law has from the dawn of the internet. And you may think that's good policy because states have a sovereign right to do things like that, or you may think that's bad policy, particularly in connection with broader internet governance. I'll be honest, I think it's bad policy, but people can have different views. All right, last piece of this, how does this relate to security? Well, content moderation includes lots of things. The big hot button issues about, whether President Trump is banned from Twitter or whether this or that, conservative broadcasters banned from social media platform are one thing. But, social media platforms ban terroristic videos, right? Or recruitment to terrorist organizations, whether that's a white supremacist organization or ISIS, right? Have limits on hate speech, content that incites to violence, as we've seen, stalking, harassment, those kind of things are criminal acts on social media, can be criminal acts, and social media companies do remove them. And then there's other community norms. I mean, YouTube doesn't allow pornographic content. Other sites, sell pornographic content. That's their business model, right? And you can have a market that differentiates them. So all these things are security concerns, and if you're going to treat social media companies as common carriers, there will be questions, I think, about content moderations in all these other areas, particularly because this question of hate speech or terroristic content, is a place that the lines get kind of smashed together. For some people, Alex Jones is, a political dissident who should have his platform. For other people, Alex Jones is not only a huckster, but is promoting, when he talks about false claims about the Sandy Hook massacre or something like that, is promoting forms of hate speech and harassment that should be banned. Well, what do we do with those kind of cases? That makes all of this really interesting. And that's what I want to highlight for you in this video, and I hope you enjoy reading those cases and talking about them this week.